Warden, Maryland Penitentiary v. Hayden, Supreme Court, 1967. About 8 a.m. on March 17, 1962, an armed robber entered the business premises of the Diamond Cab Company in Baltimore, Maryland. He took some $363 and ran. Two cab drivers in the vicinity, attracted by shouts of "Hold up," followed a man to 2111 Cocoa Lane. One driver notified the company dispatcher by radio that the man was a Negro about 5 foot 8 inches tall, wearing a light cap and a dark jacket, and that he had entered the house on Cocoa Lane. The dispatcher relayed the information to police, who were proceeding to the scene of the robbery. Within minutes, police arrived at the house in a number of patrol cars. An officer knocked and announced their presence. Mrs. Hayden answered, and the officers told her they believed that a robber had entered the house and asked to search the house. She offered no objection. The officers spread out through the first and second floors and the cellar in search of the robber. Hayden was found in an upstairs bedroom, feigning sleep. He was arrested when the officers on the first floor and in the cellar reported that no other man was in the house. Meanwhile, an officer was attracted to an adjoining bathroom by the noise of running water and discovered a shotgun and a pistol in a flush tank. Another officer who, according to the district court, was searching the cellar for a man or the money, found in a washing machine a jacket and trousers of the type the fleeing man was said to have worn. A clip of ammunition for the pistol and a cap were found under the mattress of Hayden's bed, and ammunition for the shotgun was found in a bureau drawer in Hayden's room. All these items of evidence were introduced against respondent at his trial. We agree with the Court of Appeals that neither the entry without warrant to search for the robber nor the search for him without warrant was invalid. Under the circumstances of this case, exigencies of the situation made the course imperative. The police were informed that an armed robbery had taken place and that the suspect had entered 2111 Cocoa Lane less than 5 minutes before they reached it. They acted reasonably when they entered the house and began to search for a man of the description they had been given and for weapons which he had used in the robbery or might use against them. The Fourth Amendment does not require police officers to delay in the course of an investigation if to do so would gravely endanger their lives or the lives of others. Speed here was essential, and only a thorough search of the house for persons and weapons could have ensured that Hayden was the only man present and that the police had control of all weapons which could be used against them or to effect an escape. Here, the seizures occurred prior to or immediately contemporaneous with Hayden's arrest, as part of an effort to find a suspected felon armed within the house into which he had run only minutes before the police arrived. The permissible scope of search must, therefore, at least be as broad as may reasonably be necessary to prevent the dangers that the suspect at large in the house may resist or escape.